Hello. Welcome back to All Up in Your Business. I'm attorney Aiden Durham with 180 Law Co. in Colorado. This is my darling, sweet little bird. And today we're going to go through your comments and answer your legal questions and have a lot of fun as we do it.
Okay, little bird? Okay, great.
But first, before we do all of that stuff, if you're new to All Up in Your Business, welcome. Please subscribe if you haven't already. Click that little bell so you get notified anytime I post a new video, and make sure to check the description for links to additional information and resources. And while I am a lawyer, I am not your lawyer. The stuff I talk about in my videos should not be taken as a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer who's licensed in your state. All right, enough of that. Let's get into your questions and stuff. If one changes any image or message from the document which is copyrighted, so this is a copyright question, is it required to update copyright year also? If he do so, needs your suggestions. Is it required to update the copyright year? It's not required. So I'm guessing this question is about the little copyright notice that we see on a lot of the bottoms of documents, materials, websites, movies, books, that kind of thing. No, you don't have to update the year. That in itself isn't going to like invalidate your rights or anything. With respect to actual copyright registration though, if you have a copyright registration for a document that contains messages or images, words, something, and you change something on that document, you change the pictures, you revise, you update some of the information, do you need to then re-register, reapply for the document with that, with that new info? No, again, you don't need to, but typically we will re-register to capture whatever is new in that kind of updated version of it. But with this question, with the year on the little copyright notice, you can change it. You don't have to. It's not going to really have any significant impact. Okay, there's little bird showing off her little bird to everybody. That's so sweet. That's so nice of you to do, Birdie. Thank you. USPTO, the structure search is confusing. If I type in Joe's Garage Coffee, I get results from anywhere and from everywhere, and I don't even see any of those words in the results. I'm going to check out Trademark Clear. Thanks. So this came up from my recent video about how to do a trademark clearance search online, and I talked about some free resources for it. One of them was this website, Trademark Clear. There isn't really a question in this, but I'm bringing it up because the timing couldn't have been better. Literally, I think the day I published that video, the day that video went out, the USPTO launched their new updated search system. So that was cool that everything I talked about with regard to the test system is now out of date, but I encourage you to check back, play around with their new search system. I haven't done it myself, but I understand that it's a bit more user-friendly and a bit more easier to do a real search. But yes, I can validate your feelings that the structured search is very confusing and you don't really get much info out of it. So you are correct, yes. I'm a sole proprietor, but I have a prospective new client that wants me to be an LLC. I have existing contracts with clients as a sole proprietor that might be difficult to change. Is it possible to bill some clients as a sole proprietor and some as an LLC? I don't have any DBAs currently. Is it? I have some things to say in response to this. Is it possible to bill some clients as a sole proprietor and some as an LLC? Yeah, that's possible. You could form an LLC and just bill this one client and just contract with this one client through the LLC. Yeah, I guess you could do that. I don't see why you couldn't. But why would you want to is the better question. Like if you're forming an LLC, if you're going through all the hassle and work of forming an LLC just for this one client, I don't know, that hardly seems worth it. Like if you've got the LLC, why not just start operating as an LLC at that point? You've got existing contracts, you said. It's possible that you could assign those contracts to the LLC or maybe, depending on the nature of them, maybe terminate and restart the contract under your LLC. There are ways to rectify that situation. My bigger problem, my bigger I have a new client that wants me to be an LLC. Why is your client telling you anything about how to structure your business? That's the part that I'm not totally clear on. Okay, cool, your client wants you to be an LLC. I want to be a millionaire. Things don't just happen because we want them to. Why does your client care? I'm guessing it's stemming from them being concerned about like independent contractor classification, because that's a big thing. If we pay you as an LLC, it makes it easier for us to call you an independent contractor. But you shouldn't be changing your business structure to appease one of your clients. So I'd say dump the client or tell them, sorry, I'm not changing my entire business structure for you. But if you really want to, yeah, you can do that, I guess. You could do that. Someone said that if my business name is ABCD LLC, I should file a DBA to just use my name as ABCD, because if one forgets to put the LLC in their name, you may end up with issues, such as when writing a check. If I forget to write LLC after ABCD, the checks may be invalid. Can you confirm, or what are your thoughts? The LLC was a requirement when applying for an LLC. Yes, so that is a requirement. I'm almost certain in every state and every jurisdiction that when we're forming an LLC, we have to put some designator at the end, whether it be LLC or LTD. We can spell out limited liability company. We have to have something like that in the business name. So should we file a DBA so we can go under just the business name without the LLC? My opinion is no. I don't see the point of it. Like, I guess there's no harm. There's no harm in doing that, but I don't see the point. Like, you don't have to have LLC in the name everywhere. In every single time you mention your business name, you don't have to include LLC. It's mainly on like the legal documents, contracts, obviously, bank accounts. We want to have the full legal name, which is LLC, that kind of stuff. And if we waver on that, like using the LLC on maybe marketing materials, that itself isn't a big deal. If you forgot, so if someone was writing out a check to your company and put as the pay to, if they put ABCD and left off the LLC, I'm almost certain your bank would still accept that. They'll see that this check was written to this, owner. I don't know why you would write a check and not put LLC in the name. Like, your checks should have the business name already printed on it, and just put LLC in the business name. What's the problem? It won't invalidate the check, is my point. I guess the answer is I don't see a need for it. I don't think it's necessary, but I guess there's no real harm to it either. Hi, Aiden. I love your videos. Thank you. Very helpful. May I ask you a question? Yes, you may. If I want to trademark on the USPTO with a name with XYZ in lowercase, but I searched and I saw someone registered XYZ Studio in all caps and the status is active, and another person registered Harry XYZ in all caps and the status is dead. Do you know if I can still trademark XYZ? Thank you and appreciate your answer. So first off, the capitalization, lowercase, uppercase doesn't make a difference if we're talking a standard character mark. So not a logo, not a design. Standard character marks, the case doesn't make a difference. XYZ in all lowercase is identical to XYZ in all caps. So if we're looking side by side, XYZ lowercase and XYZ Studios, assuming they are in the same or a similar class of goods and services, if the goods and services are related, then yeah, I would be pretty certain that the USPTO would find those to be confusingly similar, because studio is a descriptive word. They're going to most likely make that, well, it's registered, I guess. But studio is descriptive. We don't give a whole lot of weight to these descriptive terms. So the USPTO is really going to zoom in on the dominant portion of the mark, which would most likely be the XYZ. So now they're just looking XYZ versus XYZ, they're identical. So it's going to come down to the goods and services. And since the marks are so similar themselves, the closer related the goods and services are, the higher chance that it will be rejected. This other one, hairy XYZ, if it's dead, isn't going to make a difference. Dead marks aren't taken into account. They're not part of the evaluation. They won't be a basis for which our trademarks might be rejected or denied. So all that said, if your goods and services are completely different than the XYZ studios are, then you might be able to get it registered. But it still kind of depends on what XYZ means. Like if XYZ is Disney, then no, you're not going to be able to get Disney registered for pretty much anything because Disney already owns pretty much everything. My biggest issue is copyright infringement on my graphic design work on clothing. How are those protected? I don't want to trademark or register everything I draw or print. How can those be protected? So graphic designs on clothing, they could potentially be considered trademarks and you could register them as trademarks, maybe. But outside of that, it sounds like they are more protectable by copyrights. And any original creation, if these designs are your completely original designs, then you already have copyright protection in them. Without doing anything else, as soon as you slap one of those designs onto a piece of clothing, or otherwise fix it in some form, you've got copyright ownership and copyrights in it. And you don't have to put the TM symbol or the R symbol on it because we're not dealing with like trademarks, we're dealing with copyrights here. And that in itself gives you some protection, but the best protection is going to come from registering those copyrights because that gives you now a lot more rights and other damages and options available to you in the instance of copyright infringement. So if you register the copyrights in those designs and you see somebody else now is making clothing with those same designs, you'll have at least some action under your copyrights, under copyright infringement to do something about it and hopefully get them to stop and maybe collect whatever money they might have made off of your work. I've had my LLC for 3 years and have a website where I've made sales. However, I never had a logo for my business. I now have someone making an original logo for me. When the logo is ready, should I upload it on my website and start using it, then file a statement of use along with my trademark application? Is my use date the date I started using the logo? My fear is the application will be denied because I've been running my business for 3 years, but my logo trademark use date will be new. Also, I want to trademark a clothing line under the same business. Should I do one application with both trademarks or 2 separate applications? I'm going to kind of walk backwards. Name, business name, and logo. Should I do one application with both trademarks or 2 separate applications? It's going to be 2 separate applications. We can't do more than 1 trademark per application. So if we're dealing with 2 trademarks, it's going to be 2 separate applications. Is my use date the date I start using the logo? Yes. So when we're talking trademark application, trademark registration, we have to specify the date of first use of the trademark in connection with the goods and services that we indicate. And it's the date of first use of that trademark, not like of this other trademark. So if we're applying for this new logo you've got, it will be the date of first use of that logo. So it would be, if you've been in business for 3 years, but the logo is brand new, your date of first use would be, the current date. And then when it's ready, should I upload on my website and start using it, then file a statement of use with your trademark application? Yeah, I think that's the way I would go about it. Because you really, if the logo isn't totally ready, if you don't have the actual final design of it, you probably don't want to do an intent to use application yet, just in case the logo changes or something. So yeah, once it's ready, once it's done, pop it onto your website. I mean, I don't know exactly what your goods or services are, so your website may not be enough for the statement of use. I can't guarantee that, but usually it is. So yeah, pop it on your website, pop it on, your stuff, your materials, if you're selling clothing. Well, you said you're selling clothing. So pop it onto your garment tags, your labels on your clothes, and then, then you can file it on a 1A basis with the statement of use along with the application. I think that sounds like a good plan. Do you have to file separate applications for the printed book and the ebook from the same manuscript? So this is a copyright question again. Separate copyright applications for the printed book and the ebook from the same manuscript? No, typically that's not going to be required. The copyrights, one of the rights that we have under copyrights is the right to reproduce the work, reproduce and distribute and display and perform and all these other things, the work. And so if we're registering the manuscript for this literary work, I'm assuming is what it is, reproducing it in printed book form versus reproducing it in an ebook, it's the same. We're reproducing the same work just in two different medias, in two different forms. So in that case, no, you probably wouldn't need to. If there's some difference between the printed form and the ebook, maybe if the text is different, then yeah, that would be a situation where you would want to do them separately. Or if they're different, then yeah, we would want to treat them separately. But if it's the exact same manuscript, everything's the same, then nope, you just need to do the one. How many LLCs can one person or family have legally? How does one make sure that all the funds and monies are hidden from view? Therefore, I ask, how many LLCs can one family have? As many as you want. I'm not aware of any state that has like a limit or a restriction on how many LLCs one person or family can form. How does one make sure that all the funds and monies are hidden from view? That part I don't know. Hidden from whom exactly? I would hope you're not like publicizing your financial statements and your account info. That part I don't know how to answer, but how many? As many as you want. All right, last one here, I think. Let's cap it off with another DBA question. Can you use DBAs across state lines? Example is a provider seeing patients via telehealth, etc. Can you use a DBA or do you need to have it under an LLC? Wait, those are two different questions. Can you use a DBA across state lines? Yeah. I mean, so if you're providing telehealth, there might be issues outside of it just being the DBA. You might have other licensing issues with you providing these services across state lines. But if we're talking specifically the DBA, yeah, you can use a DBA across state lines. Can you use a DBA or you need to have it under an LLC? I don't see why you would need to have it under an LLC. The LLC isn't going to affect whether you can or can't use it across state lines. Again, there may be some other regulatory requirements if you're in the healthcare industry, but no, you don't have to have it under an LLC. You might, depending on the circumstances, the situation, you might still have to register, like if you do have an LLC, you might still have to register it as a foreign entity in that other state though, maybe. Kind of depends. Best to talk to an attorney about that one though. All right, cool. If you learned a thing or two, go ahead and give me a thumbs up, won't ya? Make sure you subscribe, click that little bell so you get notified when I post a new video. Check the description for links to additional information and resources, including a link to download my free trademark guide. We had a lot of trademark questions, so if you have more, if you want to learn more about trademarks, you can get my free guide down in the description. And speaking of trademarks, let's keep talking about trademarks. I've got another really great trademark video right here. I'll meet you over there. Thank you so much for watching. I'm Aiden Durham, and I'll see you next time.